Okay guys, bago ako magsimula sa ating bagong video, may gusto lang akong i-clarify sa nabanggit ko sa naunang video upload, no, na yung mga natanggal na empleyado brought about by valid causes or just authorized causes are not entitled to separation pay except kapag may CBA or company policies na meron silang separation pay. Kapag meron sa collective bargaining agreement or CBA nila, entitled sila to a separation pay. Kung wala, they are not entitled to a separation pay as a general rule. Kapag na-terminate ang employment mo because brought by valid causes or just or authorized causes under the labor code, you are not generally entitled to a separation pay. Now, meron tayong nababanggit na collective bargaining agreement or CBA. Sa video na to, dito natin tatalakayin kung ano ang collective bargaining agreement at CBA. But beforehand, tatalakayin muna natin yung Unfair Labor Practices Act. Sa labor kasi meron tayong tinatawag na Unfair Labor Practice. Unfair Labor Practices Act can be committed by the employer and a labor union. Two sides. Ano ba ang nature ng unfair labor practice? Okay, the nature of unfair labor practices is inimical to the legitimate interests of the management, both the management and the labor, including the right to self-organization, right to bargain collectively, and otherwise deal with each other in an atmosphere of freedom and mutual respect. Unfair labor practice disrupt industrial peace. Unfair labor practice can be a crime against the state, and Unfair Labor Practices Act violates the constitutional right of the employee to self-organization. And Unfair Labor Practices Act creates unstable labor management relation. That is the nature of unfair labor practices. Yun yung nature. Now we proceed to the elements. Of unfair labor practices. That there should be an employer-employee relationship. Yun yung unang element ng unfair labor practice. The second is yung act constituting an unfair labor practice should be defined and enumerated sa labor code. Okay? Those are the two elements of Unfair Labor Practices Act. We proceed to the principles concerning unfair labor practices. It is a practice unfair to labor, although the offender may either be an employer or a labor union. Yun yung two sides. It can be committed by the employer or a labor union. The prohibited acts are related to the workers' right to self-organization and the observance of a collective bargaining agreement. Now, without this element, the acts, even if unfair, are not unfair labor practice. Okay? Ang unfair labor practice is commonly connotes anti-unionism. Unfair labor practice has a technical meaning. Without acts opposed to workers' right to organize, without acts, opposed to workers' right to organize, no matter how unfair, is not unfair labor practice as legally defined under the code. It refers to gross violation of CBA provisions. Now, gross means is the malicious and flagrant refusal to comply with the economic provisions of the collective bargaining agreement or CBA. Please take note that if the violations are not gross, it shall no longer be treated as unfair labor practice, but it is a grievable issue. Economic provisions and not gross, it is a grievable issue that can be brought to the grievance machinery under the collective bargaining agreement. Unfair labor practice cases are not in view of public interest involved subject to a compromise. Okay? Hindi siya subject to a compromise yung unfair labor practices. But may isang case which the Supreme Court decided na yung compromise is valid involving an unfair labor practice na sinettle kasi yun ng kumpanya. Okay, na the compromise. The Supreme Court said that ang reason ng Supreme Court is the agreement is entered voluntarily entered into and represents a reasonable settlement, thus it binds the parties. The Supreme Court respected the compromise agreement entered into between the labor and capital. Although the rule is unfair labor practices is not subject to a compromise agreement or outside or beyond the sphere of compromise settlements. Now, meron tayong dalawang aspect of unfair labor practice. This is the unfair labor practice in civil case and unfair labor practice to a criminal case. Okay, the two aspects of unfair labor practice are civil and criminal. In civil, the person liable are officers and agents of employer or labor organizations or labor officers and agents in civil. In criminal aspect of unfair labor practice, the person liable are the agents and officers participated or authorized or ratified the act, and agents, representatives, members of their boards, including ordinary members. As to person liable, yan ng criminal aspect ng unfair labor practice. Sa jurisdiction, kaninong jurisdiction na ang unfair labor practice? Sa civil aspect na unfair labor practice, ang may jurisdiction dyan is the labor arbiters of the National Labor Relations Commission. Sa criminal case, since it is criminal aspect, either the municipal trial court or the regional trial court. As to quantum of proof, in civil, we all know basic is the rule that substantial evidence is sufficient in civil cases of unfair labor practices. But in criminal, basic is the rule that the quantum of proof in criminal cases is proof beyond reasonable doubt. Yan yung quantum of proof. As to prescriptive period of unfair labor practices, in its civil aspect, 1 year from the accrual of the unfair labor practice. In criminal, 1 year from the accrual of the Unfair Labor Practice Act. Okay? That is the civil and criminal aspects of Unfair Labor Practices Act. Now, we proceed to unfair labor practices acts that can be committed by any employers. One is discrimination. Discrimination on the part of the employer to the employee. Discrimination in the sense na discrimination with regards to the wages, hours of work, and other terms and conditions of employment in order to encourage or discourage the employee to join a labor union or any labor organization. To constitute it as an unfair labor practice, the discrimination committed by the employer must be in regard to the hire or tenure of employment or any terms and condition of employment in order to encourage or discourage the employee to join any labor organization or labor union. Now the test for discrimination: whenever benefits or privileges given to one is not given to the other under similar or identical conditions when directed to encourage or discourage union membership. Discrimination occurs when a union member involved in union activity is treated differently from a non-union member. Discrimination is distinguished from classification. While discrimination is considered an unfair labor practice, classification is not, okay, because it merely differentiates the employees in accordance with their respective jobs and accords them the appropriate levels of pay or benefits due them by that reason. That is one unfair labor practice that can be committed by the employee. Discrimination for or against union membership. We have also, second is the interference. Discrimination, okay, unfair labor practice. Except, may exemption po tayo sa exemption sa discrimination kapag meron sa collective bargaining agreement ninyo the union security clause or the security arrangement. Dito sa under union security clause may iba-ibang type na naman kasi yun, different kinds of union security arrangement as an exemption to the Unfair Labor Practice Act of Discrimination. Meron sa union security clause, we have the closed shop agreement, union shop agreement, agency shop or maintenance of treasury shop, bargaining for members only, exclusive bargaining shop, maintenance of membership shop agreement, and modified union shop. Sa union security clause as an exemption to the discrimination as an act of unfair labor practice. So under pa rin tayo sa union security clause or security agreement as an exemption of the discrimination as unfair labor practice act. So may different kinds pa yan under the union security clause. We have number one is the closed shop agreement. It is an agreement whereby an employer binds himself to hire only members of the contracting union. Okay, closed shop agreement. Kung sino lang yung member ng union, siya lang ang ma-hire as an employee. And that is the prerogative of management prerogative of the employer. to hire only members of the contracting union who must continue to remain members in good standing to keep their jobs. That is the close shop agreement under the Union Security Clause as an exemption to the Unfair Labor Practice Act of discriminating employees. We have second kind of Union Security Clause or USC, Union Shop Agreement. Now, the non-members may be hired, but to retain employment, they must become a member of the union after a certain period. The requirement applies to present and future employees. That is the Union Shop Agreement. Third, Preferential Shop Agreement is an agreement whereby the employer merely agrees to give preference to the members of the bargaining union in hiring, promotion, filling up vacancies, and retention in cases of layoff. The employer has the right to hire from the open market if union members are not available. That is the Preferential Shop Agreement. Meron din yung Agency Shop or Maintenance of Treasury Shop. Is an agreement whereby employees must either join the union or pay to the union as exclusive bargaining agent is sum equal to the paid by the members. Kaya may tinatawag silang union dues at kailangan mong bayaran yun whether or not you are a union member or hindi or not, for you to be represented in the bargaining of the labor union. Please take note that this is directed against free rider employees who benefit from union activities without contributing support to the union to prevent a situation of non-union members enriching themselves at the expense of the union members. Next kind of Union Security Clause is bargaining for members only. Itong kind na to, it provides that the union is recognized as the bargaining agent only for its own members. We have also exclusive bargaining shop. It provides that the union is recognized as the exclusive bargaining agent for all employees in the bargaining unit, whether union members or not. We have also maintenance of membership shop agreement that it provides that no employee is compelled to join the union, but all present or future members must, as a condition of employment, remain in good standing in the union to keep their jobs. And the last kind of union security arrangement is modified union shop. It provides that the employees who are not union members at the time of signing the contract need not join the union, but all the workers hired thereafter must join. Those are the different kinds of union security arrangement. Union security arrangement is an exemption to the discrimination that would constitute an act unfair to labor. Those are valid discrimination on the part of the employer. Those stated different kinds of union security arrangements. So number one, acts constituting unfair labor practice that can be committed by the employer. Number one is discrimination. However, discrimination admits exemption, and that is the Union Security Agreement or Union Security Clause in the Collective Bargaining Agreement. Second, acts that may constitute unfair. Second acts that constitutes unfair labor practice is interference. Ang interference, when you restrain or coerce employees in their exercise of their right to unionize or to right to self-organization. The test there is whether the employer has engaged in conduct which it may reasonably be said tends to interfere with the free exercise of the employer's right to self-organization. It is not necessary that there be direct evidence that any employee was in fact intimidated or coerced by the employer if there is a reasonable inference that the anti-union conduct of the employer does have an adverse effect of self-organization and collective bargaining. We have this totality conduct doctrine. Totality of conduct doctrine refers the culpability of employers' remarks is to be evaluated not only on the basis of their implications but is appraised against the background of and in conjunction with the collateral circumstances. That is the totality of conduct doctrine under our labor law. The third acts that would constitute unfair labor practice is the yellow dog condition. Ngayon, ano tong yellow dog condition? The yellow dog condition requires as a condition for employment that a person or an employee shall not join any labor organization or shall withdraw from one to which he is already a member. That is the yellow dog condition. Yellow dog contract is a promise exacted from workers not to join any labor organization, labor union, or to withdraw therefrom kapag he is already a member ng labor union. That is the yellow dog contract. As a condition of their employment. Next is paid negotiation. Ano tong paid negotiation? Paid negotiation is also considered as an unfair labor practice can be committed by an employer. It is to pay negotiation or attorney's fees to the union or its officers or agents as part of the settlement of any issue in collective bargaining or any other dispute. That is the paid negotiation. We have also violation of duty to bargain. In labor kasi, we have this duty to bargain. The employee is represented by the labor union in the bargaining unit and the capital, yung mga employer. So they have the duty to bargain. Violation of duty to bargain on the part of the employer constitutes an act unfair to labor practice. Next is violation of the collective bargaining agreement. Violation of the collective bargaining agreement. Violation of the CBA, also an unfair labor practice. The violation must be gross, flagrant, and or malicious refusal to comply with the economic provisions of the collective bargaining agreement. Violation of the collective bargaining agreement. The violation must be gross, flagrant, and or malicious refusal to comply with the economic provisions of the collective bargaining agreement. Gross violation of the collective bargaining agreement is defined as flagrant or malicious refusal by a party thereto to comply with the economic provisions thereof. Now, what is violated therefore is a non-economic or a political provision of the collective bargaining agreement, the same shall not be considered as unfair labor practice and may thus be processed as a grievable issue. Grievable, so since it will be processed as a grievable issue, it could only be settled in a grievance machinery since it is already non-economic provision of the CBA or a political issue in the CBA. So it would no longer be an unfair labor practice but a grievable issue. No, the appropriate remedy is to set it in a grievance machinery as stipulated or agreed upon in a collective bargaining agreement between the labor union and the employer. Now, if the violation of the CBA is not gross, it is not unfair labor practice, but only a grievance under the CBA. Ang gross violation sa CBA as flagrant and or malicious refusal by a party thereto to comply should be economic provision. Dapat economic provision of the CBA ang flagrant and maliciously refusal to comply. Kasi kapag ang involved ay non-economic or political provision of the CBA, the same shall not be considered as unfair labor practice and may be processed as a grievable issue and hence be settled in a grievance machinery under the CBA. The next is discrimination because of testimony. Discriminate mo yung isang empleyado because he or she is about to give testimony under the labor code. Next is outsourcing or contracting out. Yung nag-contract ka ng ibang serbisyo na yung trabaho naman na pinakontract mo is being performed by union members when such will interfere with, restrain or coerce employees in the exercise of their right to self-organization. Okay? You contracted out a job where in fact union members can perform or already performing such a task. You contracted out. That is contracting out. That is unfair to labor practice. Outsourcing, yung kumuha ka ng ibang trabahador, is not per se an unfair labor practice. Basta lang it is motivated by good faith and must not have been resorted to circumvent the law or must not have been the result of malicious or arbitrary action. Hindi naman bawal per se, hindi naman bawal ang outsourcing or contracting out. Basta it should be done in good faith and it should not circumvent any labor laws or related laws. Next is company domination of union. It means to initiate, dominate, assist, or otherwise interfere with the formation or administration of any labor organization, including the giving of financial or other support to its organizers or supporters. Company domination of union, that is also one form of unfair labor practice that can be committed by the employer. The enumeration of acts constituting unfair labor practice are not exclusive. Kasi meron din sinasabi na unfair labor, union busting, unfair labor practice din po yun. Gross violation of the collective bargaining agreements, unfair labor practice din po yun. So hindi po exclusive doon sa mga nabanggit natin na that can be considered an act unfair to labor practice that can be committed by the employer. Next is unfair labor practices of labor organizations. The labor organizations committed an act unfair to labor when to restrain or coerce employees in the exercise of their right to self-organization. However, A labor organization shall have the right to prescribe its own rules with respect to the acquisition and retention of union membership. Under Article 259, an employer commits unfair labor practice through interference, restraint, or coercion. But in Article 260 on unfair labor practice, a labor organization, interference is left out. Interference by a labor organization in itself is a function of self-organization. However, if the interference amounts to restraint or coercion, then it becomes an unfair labor practice. Second is to cause or attempt to cause an employer to discriminate against an employee, including discrimination against an employee with respect to whom membership in such organization has been denied, or to dismiss an employee on any ground other than the usual terms and conditions under which membership or continuation of membership is made available to other members. Please take note that a union member may not be expelled from the union and consequently from his job for personal or impetuous reasons or for causes varying to the close shop agreement.
Happy New Year. Happy greetings.
The next act that would constitute unfair labor practice that can be committed by a labor organization is to violate the duty or refuse to bargain collectively with the employers, provided that it is the representative of the employees. Their duty to bargain. Fourth is to cause or attempt to cause an employer to pay or deliver or agree to pay or deliver any money or other things of value in the nature of an exaction for services which are not performed or not to be performed, including the demand for a fee for union negotiations. Feather bedding. We have also feather bedding or make work agreements. It is a term given to employee practices which create or spread employment by unnecessarily maintaining or increasing the number of employees used or the amount of time consumed to work on a particular job. That is feather bedding. Next act that would constitute unfair labor practice by the labor organization is to ask or accept negotiation or attorney's fees from employers as a part of the settlement of any issue in collective bargaining or any other dispute. The next is, and also grossly violate the collective bargaining agreement. Who are these persons civilly liable for unfair labor practices? Officers and agents of employer, labor organizations, officers or representatives and agents, and officers who participated or authorized or ratified the act. We have also the sweetheart contract. Sweetheart contract is a collective bargaining agreement which provides for terms and conditions of employment below minimum standards established by law. Below minimum standards established by law. That is a sweetheart contract. We have also blue sky bargaining. Ano ang blue sky bargaining? It is defined as making exaggerated or unreasonable proposals. Whether or not the union is engaged in blue sky bargaining is determined by the evidence presented by the union as to its economic demands. Thus, if the union requires exaggerated or unreasonable economic demands, is guilty of unfair labor practice. Please take note that the labor code does not authorize the employer to close down the establishment on the ground of excessive demands of the union. Instead,
September 29.
aside from the remedy of submitting the dispute for voluntary or compulsory arbitration, the employer may file a complaint of unfair labor practice against the union for bargaining in bad faith. Now, if found guilty, this gives rise to civil and criminal liabilities and allows the employer to implement a lockout, but not the closure of the establishment, resulting to the permanent loss of employment of the whole workforce. So that is the unfair labor practice. Unfair labor practices acts that can be committed either by the employer or by the labor organizations. For our next video, we will be discussing the collective bargaining agreement. Procedure in collective bargaining: duty to bargain collectively in the absence of collective bargaining, duty to bargain collectively when there exists a collective bargaining agreement, exclusive bargaining representative, determining the bargaining union, SEBA certification election. We will end in certification election. For the next video, we will now talk or discuss about collective bargaining agreements up to certification election. So thank you for watching, guys.